the order granted, judgment granted by Justice Sbu Ngalwa, who was delivering this rescission application. The order is there right at the end. Direct access is granted. Also saying the application for rescission is dismissed, and former President Jacob Zuma must pay costs, as we try, of course, to make sense of some of the elements that came out of this judgment. A lot of the arguments that had been put forward by Zuma's legal team fleshed out to the fullest here as the Constitutional Court majority reveals their findings. I'm joined in studio by Newzroom Afrika's politics editor, Sbu Ngalwa, as we try and go through the points that were made by Justice Ngalwa as she delivered this judgment. Sbu, some interesting elements coming out of this as we look at the arguments that had been put forward by former President Jacob Zuma's legal team, speaking of that he was sentenced to prison without a trial, and also bringing in that international law argument. Both those elements didn't hold much substance.
That's correct, Paul, and I think the important point here for the viewers as well is that they probably had Justice Ngalwa kept referring to Rule 42, and perhaps it's important to also explain what that rule is about, because that was actually the basis of the application that was brought by the former president. He had brought it in terms of Rule 42 of the Uniform Rules of the Court, and that would have been read with Rule 29 of the ConCourt. Yeah. Now, those are the rules that deal with the fact that a court, which says that a court may vary or rescind its decision if the affected party was not present or in the absence of the affected party. Now, that was the issue here, and you heard Justice Ngalwa saying that in the case of Mr. Zuma, it was elected absence. Yes. It's not that he had been left out of the proceedings unfairly. He had been given an opportunity. Even going back and citing their earlier judgment, you will recall that after the Constitutional Court found Mr. Zuma to be guilty of contempt, in fact, after they had ruled that he must appear before the Zondo Commission, he failed to do so, and then the Commission then asked the Constitutional Court to find him guilty of contempt. He was given an opportunity in April, yes, where he was asked to file an affidavit. Instead, he wrote a letter back to the Constitutional Court saying he will not participate. So the court takes issue with this to say that if they were to allow him now, would actually to render the whole process useless, in that he had all the opportunities to state his case. He had all the opportunity to come before court and state his case. But now, because the case went against him, that is where he was sentenced to 15 years, now he wants to be admitted. So they cannot allow that to happen. I think those were some of the basic points there, Paul. Part of the argument advanced by the former president's legal team was that the sentence by the Constitutional Court, because the Constitutional Court is the ultimate court, it's the apex court, its rulings and its orders and its judgments cannot be appealed. And they had argued that because Mr. Zuma had not been to court and that he had not pleaded, that his detention was without trial, and then they had sought to invoke international law, and they brought in the United Nations International Covenant on Civil and Political Rights, now which says that no detainee, or rather no suspect, should be detained without trial. So they are saying that in as much as South Africa and also our judiciary does observe international law, in this instance, that treaty does not impose, does not oblige South African courts to regard it or to actually consider it, and that they can only do that insofar as international law is considered. Let me just go back to a point that Judge Ngalwa made, where she says that that treaty, international law, it doesn't oblige South Africa to take direction from international law. And it also, the way they say that they also dispute the relevance of the international treaty on South African court. Now, here's an interesting point, Paul. This is where the court, in its majority, finds that that treaty is only binding to South Africa at an international level, meaning that South Africa has the right and the autonomy, its courts, to decide their laws based on the Constitution.
Another really important element, as the Justice Kampepe spoke about former President Jacob Zuma's behavior, really coming out strongly to protect the integrity of the Constitutional Court. As she spoke about that, spoke about the attitude of the former president and, you know, how he didn't show the respect that he was meant to show with this decision, and that is why we've come to this conclusion. In
fact, that point was made sharply, and Justice Kampepe had made it very strongly in the original judgment, where he had imposed that, where the court imposed that 15-month sentence on the former president, where they actually were also pointing out the fact that they said that the court had never been disrespected in that manner by anyone, and least of all, and more importantly, this is a former president of the country. And you can hear, even in reading this judgment, the point that she seems to be making is that it was important for the court to actually restore the respect for the rule of law, and also to make an example of the former president, to show that no suspect, criminal or in a civil matter, can just disregard the findings or the judgments of a court.
What does this now mean for former President Jacob Zuma? I mean, we know that much of the reporting has been on his ill health. It's revolved around that medical report, and that's where we've been standing with him personally when it comes to his sentence.
Look, I think this goes into the annals of legal records in this country in terms of the Rule 42 of the Rules of Court. But I think in reference to the former president, the reality is that this judgment now comes at a time when he's already been granted medical parole. So what bearing does that have on that case? Well, it has a bearing insofar as the application, the challenge that has been brought by the DA, and I think also the Helen Suzman Foundation, but I stand corrected there, who have challenged his medical parole. So if the court, in the medical parole matter, finds that the Director General of Correctional Services erred in granting that or in overriding the decision of the parole board, then that would mean that Mr. Zuma would have to return to jail, effectively. That's what it would mean. That's how it relates to this. But if that court finds that Arthur Fraser was well within his rights to make that finding, the reality is that the former president will remain outside, will be out of jail on medical parole.
So where do we move from here? I mean, this is not the only matter that's well, hanging over the former president's head. There is also the arms deal matter that hangs over his head as a former statesman. So
insofar as the contempt of court judgment and his sentence to 15 years, this is a finality. This is the end of the matter. But obviously, as you are saying, there is also a case that is coming up before the Pietermaritzburg High Court on the 21st and the 22nd of September. Now, that is in relation to the arms deal case where he's accused of having accepted a 500,000 bribe. Now, what is meant to happen in court is that the court is supposed to hear his application. Remember that in that case, he had applied for the prosecutor, Billy Downer, to recuse himself from the trial, saying that Billy Downer was biased against him, but also going further and accusing Billy Downer of having leaked sensitive medical information to the media. Of course, this is denied by the NPA. Now, that is the matter that will be heard in the Pietermaritzburg High Court on the 21st and the 22nd. And as I said, this is not related to the challenge now to his medical parole, because he's currently, he may be in hospital, but he's out on medical parole.
Which is something of importance. But as we go back a little bit and really reflect on this decision by the Constitutional Court and how it was really at pains to protect the reputation of the rule of law, especially perhaps setting a precedent for anyone else who might want to try to be in the position that former President Jacob Zuma was in when it comes to his response to the rule of law.
I think that was the biggest issue for the court, given the fact that, and that's why they also made reference to the fact that the former president was not just any ordinary person. This is someone who had vowed and swore they took the oath to abide by the Constitution not once, but on 2 occasions. So the consequence of his contempt actually had a far-reaching implication, also given the political ructions that we have seen in parts in KwaZulu-Natal and parts of Gauteng following his incarceration. So I think, if anything, this judgment, as did the original one, does restore the supremacy of the Constitution, that all of us are equal before the law, regardless of our political position or our stature or sex or social standing.
Yes. Very well. Let's leave it there for now.